We consent to being recorded. I like that. I've never seen that before, Destiny.
If you say no, are you gonna get kicked off? Is that what's gonna happen to the attendees?
Right.
I don't know. I don't know.
You are consenting.
Yeah, I've never seen that that consent to recorded thing. Hi, Marvina. How you doing? I think we're having a little trouble with the audio for Marvina.
It doesn't look like she's connected via audio, just the video. The microphone symbol is missing.
Marvina, raise your right hand if you can hear us. Destiny, could you call her on the cell phone and work with her? Well, let's go ahead and get started since it is 3 o'clock and people are starting to populate in. So we want to make sure we use the time most efficiently. So folks out there in social equity land, my name is Dimitri Downing from META. Thank you again for joining us for another informative seminar. We'll be about an hour and a half today, maybe a little bit shorter. We have some good information to provide for you about the latest version of the rules, which I believe is the final version, but I'll let Dr. Humble get into that, as well as our panelists. First, I'd like to thank all of our sponsors that make our ability to help educate the community and public out there about social equity possible. 420 Skincare, can we hear from you, Marvina, yet? No, Marvina is there working on her audio. We'll get that.
She's connected with her cell phone.
She's what?
Marvina's connecting through cell phone right now.
Okay, fantastic. And we'll get back to 420 in a second. Marvina is a wonderful supporter of META and the Social Equity Project. We also have Scottsdale Community College, Zuber Lawler, Copper State, and Weed Maps. Thank you for your ongoing support. We have in-person events coming this summer. We have a new sponsor for that. We have the 420 Deep Dive coming this summer, which is going to be a tremendous amount of information about how the industry works, presented by national level sponsors, not sponsors, just national level experts. And the reason why we don't need any sponsors for that is because 420 stepped up and helped us take care of that. So we have all this expertise and knowledge coming to share with social equity applicants. Let's see. So the next META is June 23rd. Give us an email if you want to know more about that. But now let me quickly let our panelists to introduce themselves, and they're going to take 30 seconds, let you know who they are. The focus is going to be on Will Humble's presentation, his PowerPoint, which has been fact-checked, I understand, which is interesting. But first, before we get to Will Humble, let me see if Marvina, are you with us yet? No, not. Okay. Is your audio working? Okay, we'll come back to you. Jeff Tice, tell us about who you are.
Hi, Dimitri. Thank you. I'm a CPA, ex-license holder. I've been involved in cannabis here in Arizona extensively since about 2011. Specialized in organization, valuation, finding funding, and helping companies be successful.
Thank you, Jeff. And Jeff has helped put together the curriculum and information that we've been providing out there in the public. Our website is filled with information about the industry that's helpful, not just to social equity applicants, but anyone in the state of Arizona. And Jeff is one of the people that, as a senior member of the Arizona cannabis industry, has been giving back. Next, let me present Clark Wu from Bianchi and Brandt.
Thank you, Dimitri, and hi, everybody. Thanks for having me back, META. As Dimitri said, my name is Clark. I'm a business attorney and litigator at Bianchi and Brandt, which is a full-service cannabis law firm located here in Scottsdale, Arizona. I'm licensed to practice here in Arizona and also in the state of Missouri. Our firm services cannabis operators of all sizes, from smaller individual license holders to multi-state operators and international public companies. So we're happy to be here today and share knowledge with all of you regarding the social equity program. I'm excited to get into this discussion. So thanks again, Dimitri.
And thank you, Clark, and thank you to your law firm, Bianchi and Brandt, Guidant Law, Zuber Lawler, Rose Law Group. You guys are some of the experts in the cannabis field in Arizona, all associated with the Arizona Cannabis Bar Association. And we thank you for all your volunteer work. It really helps to have a large group of lawyers committed to helping people understand things. So thank you for your volunteer work. Next is Jonathan Udell from Rose.
Thank you, Dimitri. You actually had it right the first time there. My name is Jonathan Udell. I'm with Rose Law Group. We're a full service law firm. I focus on cannabis law myself, focus on particularly regulatory compliance, and did a lot of work in the last application round, helping folks from all over the place try to apply for those rural county backfill licenses. So in addition to my practice with Rose Law Group, I'm also on the board of directors of Arizona Normal and the communications director. So played a pretty big role trying to get Prop 207 across the finish line last fall. And it's really exciting to be here with you all today talking about the social equity program, which of course was a big reason for Prop 207's success. So thank you for inviting me, Dimitri, and thank you everyone for joining us.
Thank you, Rose Law Group, for everything you've done in cannabis for a decade now. Alex Karam, am I pronouncing that correctly? Karam from Guidant Law, replacing Gary Smith, who's unavailable today from I think he's the president of the Arizona Cannabis Law Bar Association or something like that.
Yeah, Cannabis Bar Association, yes. And I'm the treasurer of the association. I'm also a founding member. And I'm an attorney with Guidant Law. It's a full service law firm, but we do specialize in cannabis law. We've helped dispensaries and vendors that work with dispensaries, both on the transactional side and in litigation as well. So we do the regulations, setting up structuring, things like that. It's a pleasure to be here. Very excited to talk about the social equity program and these final rules. Looking forward to helping out with everyone. Thank you.
And again, folks, when you're choosing out there what lawyer to use to form your LLCs and all your other stuff that you just have to do, trust me, I know, call me, I'll tell you a horror story. Guidant Law, Rose Law Group, Bianchi and Brandt, Zuber Lawler, all have stepped up for the last 6 months to help educate the community and give back. So I highly recommend using them and their services. All extremely talented individuals getting really in depth on this stuff. And if you need to understand the financial aspect of it, call Jeff Tice. But that's he's the finance wizard of the Arizona cannabis industry. Marvina, do we have a chance to hear from you? Are we live yet with you? We got to unmute there. No, it's still muted. We will come back to you after Will Humble does his first slides. So Will, why don't we let you go ahead and take it away and do the share screen. Will Humble is going to present his slides, and then everyone is welcome to interrupt and say he's wrong or he just doesn't understand or the old man is wrong. What was that from, Tom Cruise, some movie? Anyways, so, but you're not old, Will, you're young and everything. So anyways, Will Humble, folks.
All right, thanks, Dimitri, and thanks for the opportunity again. So I'm going to jump right into it. I still need to get my participant screen share authorized.
Is that authorized, Destiny?
There we go.
Try, Will.
We're good now. Okay, so let me go ahead and jump right in. Let me start with just some editorial comment right at the beginning. And I don't know if the other panelists agree with me because we didn't talk about this before we started, but honestly, I think the state health department did a good job on this. Setting up the final rules, it's clear that they listened to the comments that came in. Some of the things that we talked about on previous webinars are included in the final rule package. These social equity programs are hard to put together. There's no shortage of critics that are out there. And to be honest, the language that was in the act itself was wide open, which left the agency a huge amount of discretion in terms of how they built this. But it looks to me like they built it in a pretty responsible way. Maybe some of the panelists don't agree with me, and we can talk about that later on. But, it looks to me like they learned from what happened in some of the other states. And as you'll see, as we jump into the criteria that they put forward to decide who qualifies to apply and who doesn't, they're pretty objective. And I've encouraged, as you know, the agency to use things that were clearly objective and verifiable as criteria. I know not all the panelists agree. I always told my staff, I don't want to grade essay papers. I want true, false, multiple choice, because that's how you can actually verify whether you got the right answer or not. Subjective answers are fraught with litigation. And in my opinion, the more objective the criteria are, the more likely that we can actually implement this program in a timely manner. And it looks to me like that's going to actually be able to happen. So the first slide here is just a big thank you to all the sponsors for all of these that we've, what is Dimitri? This is our 12th or 13th, something like that. We've been doing this a long time, and none of it would be possible without our sponsors. So here, let's jump right in. Social equity licenses, and we made it. The rules are done, and kudos to the department for getting it done on time. I'm going to blow through these first slides really fast. So the way this whole process works is the voters approved the proposition, Prop 207, and it gave a basic skeleton to the state health department to develop the adult use program, including the social equity component of that program. And it gave wide latitude to the state health department for developing the regulations, otherwise known as administrative code. Basically, what makes that skeleton turn into an organism is that administrative code. It provides the details to let all of us know exactly how the program is supposed to run. It basically writes the rule book for, in this case, what we're talking about here today, the social equity program and who qualifies to apply. I already covered that. Fortunately, the authors of 207 gave the state health department what's known as exempt rulemaking. And what that means is they can go much, much, much faster than they would ordinarily be able to go. A regular rulemaking in state government takes 2.5 years, 2 years at a minimum. Because these are exempt rules, I call it the diamond lane for developing rulemaking. That means that the agency gets to develop the rules and they file them directly with the Secretary of State. They become rule without having to go through what's called the Governor's Regulatory Review Council, which can be fraught with all sorts of landmines. And so the authors were smart in giving the agency that kind of exempt rulemaking authority, which they took advantage of. In this slide, you can see if you click onto the bottom link here, I've got a link right to the State Health Department's website with the final rules as promulgated. They filed these a week ago, last Friday, and we didn't get to see them until Tuesday because it took, it was a 3-day weekend and all. But that link will take you right to the regulations. So let's go ahead and jump right into the first of the things that you will need to know if you're a prospective social equity applicant. And this one's going to be a good one for discussion, especially with our lawyers that are on the panel. But really what it says is that, too fast, that you have to have a coalition of people that own 51% of the prospective license as part of the applicants, and those will be your principal officers and board members. And then there are some criteria that identifies what ownership actually means. And the 3 bullets that you see at the bottom of the screen here are what those mean. So what ownership actually means, it ensures that, well, let me just, Clark, why don't you go from here and sort of describe what the 51% actually means and what it means in terms of voting rights and so forth.
Of course. Thanks, Dr. Humble. In terms of the 51%, the department's referring to, the quote unquote social equity, applicant/candidates, the individual that can actually qualify and meet their criteria for submitting a social equity application for one of these licenses. Now, the department, implemented these definitions of ownership in an effort to kind of protect social equity applicants. And the first type of protection is the voting rights. So if you have, so as a social equity partner or applicant, candidate, whatever you want to call it, that individual has, or a number of individuals have to make up at least 51% of the applicant entity, whatever that might be. And those that 51% has to have voting rights commensurate with their ownership interest. So at the minimum, they have to have 51% of voting rights. Now, the second way the department has tried to protect these individuals is also to have a financial limitation, meaning that they have to receive, profits in the same amounts as their ownership interest. So if they are entitled to 51% as owners, they have to receive 51% of the profits from the company. Now, the last part is the last section and part of the definition ownership is kind of interesting because it does two things. One, it protects the social equity applicants from being subject to restrictions and assignments of voting rights that would cause violations of these protections that AZDHS has conferred to them. But second, the department's also saying you could voluntarily do these things because if you look at the last sentence, it talks about a voluntary sale. So a social equity, individual applicant who does receive a license, even if they decide after licensure that they want to sell their 51% interest, nothing in the rules as it stands right now prevents them from doing so. Back to you, Dr. Humble.
Yeah, thanks.
Let's see if the other two attorneys kind of agree with that.
That's what I wanted to do. Alex or
Yeah. No, I agree, and I think it's good because if the purpose of this is to make sure that these social equity applicants are benefiting from the program, there's ways in an operating agreement that you can make someone, let's say it's an LLC, you can make them a member, give them percentage interest, but maybe you take away their voting rights or you limit their ability to participate in some way. And so I could see people without those kind of restrictions kind of taking advantage of a social equity applicant. And so I think it's good that they have that in there. It'll prevent that kind of gamesmanship. So that's good to see. I am interested on the voluntary sale issue. You had mentioned that they don't need to be, after they've received the license, the social equity applicant doesn't necessarily need to participate after the fact. I did see, though, that in the regs, they require them to stay on board at least long enough to get a facility agent card. And I'm not sure if the purpose was that they wanted them to be part of the approval to operate process, or if they just needed to get the facility agent card if they decided to stay on board and not sell their interest immediately after getting the license.
And I would concur in general with what Alex and Clark said. If you were to look at social equity programs around the country, just do a quick Google search for social equity predatory practices. There's been a lot of criticism that various programs have taken for allowing these sort of predatory practices to occur. And I think the department was wise to do a survey of what's happened around the country and try to avoid some of those practices from happening here in Arizona. I also think it's an interesting point that was raised about the sale of the business. And I've heard a lot of comments from sort of both sides of that issue. Some people think there should be a prohibition on making sales for the purpose of ensuring that communities receive long-lasting benefits from the program. Where I tend to come down on that is I think the department made the right call in trying to make sure that this isn't some kind of a second-class license where people are locked in, because lots of folks, they want to build a business and then eventually cash out and receive some benefits from all their hard work. So I think the department was wise, number one, in preventing some predatory practices, and number two, allowing the sales to move forward.
All right. So, and we'll get at the very, very end, we're going to talk a little bit about what's something that the department added to try to ensure that that license stayed true to a social equity mission. And I won't spoil that. Those of you that read the final rules know what that is, but let's press ahead. So one of the things, yeah.
Also, if Jeff or Marvina want to just chime in at any time, you guys just chime in. Sorry, but go ahead.
Yeah. Okay. So if you recall, at the last iteration of the rules, they had you had to meet 3 out of 5 criteria, one of which was an educational class, which I personally put in comments to the agency and said, look, I don't think taking a class qualifies you as a social equity applicant. It doesn't go to how you've been mistreated by law enforcement or the unjust laws that you have in your state. It's just a class. And so I like the fact that what the agency did is remove educational training from a qualifying criteria to something that everybody has to do. So anybody who's interested in applying for a social equity license, according to the new rules, is going to, well, the 51% ownership component. So the ownership group of principal officers and board members need to take a class that the state health department will be providing. Now, it's a much more scaled back class than we talked about a week ago. It's just about operating marijuana establishments. It's about financial backing and the regulations that the state health department has for all the adult use, including the social equity licenses. So it's a scaled back class. It looks to me like it's not a whole lot of hours. I don't know how many hours this course is going to end up being, but it doesn't look very time intensive to me. But again, all of the principal board officers and board members that encompass that 51% ownership group will need to take the class before they turn in their application, which will be due at the very beginning of December. So with that, anybody would like to give any color commentary about that?
Why don't we go in the same order?
Yeah, I'll discuss briefly, and I think it's interesting because the department now split up the educational requirement into two subparts. The first is as part of the application process itself. So the social equity applicant has to complete basic training about what the application requirements are, and the state's laws and etc. And then the second part, which is after licensure, the same applicant has to complete a training course on how to operate, how to operate a dispensary. And I think this ties into Alex's point a little bit earlier about sales and when can you actually sell the business. And I'm thinking maybe what the department had in mind in requiring the candidates in doing both two things. One, in allowing the sale, but two, also potentially, I mean, there's some ambiguity in the rules, but potentially requiring the social equity person to also have, obtain their FA license and complete the second training course before they can sell. This is so that they could have an educated decision about whether or not they do want to sell the business. And after that, if they still want to sell, then it's, it's on them. But that's kind of how I'm reading the rules right now.
Yeah, I would agree. And I think it's just, we may end up with people who have never been in this situation before, where they are receiving this license that has such high value, and they're going to be approached by investors. And it's great to hire attorneys and hire other people that can help you, but I think having the department kind of set the groundwork for them to just this is what you can expect from the regulations. This is what you should look for when considering financing and sales options. I think that's a good start. And because a full restriction on sale, I don't know if that would be necessarily the easiest or best move, because we can't predict what someone's situation might be after they receive a license. But having that knowledge so that they can make that decision themselves, I think is really important.
John, you want to jump in there?
Yeah, I would agree with what Clark and Alex said. I thought the training was a pretty interesting feature of these rules. To my knowledge, that's something that hasn't been required in other states, but I do think there's a really good argument for it, because it's unclear what kind of business experience generally a lot of people are going to have. And of course, as we all know, the cannabis industry in particular is a very complex business to be going into. So I think it's great the department's going to be offering some of those services. Whether or not it should be mandatory or not, I've heard some people that are hopeful social equity applicants express some displeasure and sort of view this as a little bit of a paternalistic practice. So whether it should be required or not, I don't know. I do think that offering that is a great thing to do. And I did note also that a lot of the subjects were kind of pared back. So I'm curious to see if there will be additional training programs that pop up. And I think it'll make Mita's program too, even more important than it otherwise would have been.
I hear you. Look at that, John. You want to be back at another panel. I see what's going on there. Jeff, and then Marvina.
Well, Dimitri, I think it's always important and valuable when we have financial literacy of just about anything. And if the two most common questions I get right now is where do I get funding for the application? And what happens if I get it? And my response, really given some of the criteria here, is I've seen a lot of very good-hearted folks that would love to connect with qualified applicants. And so I'm going to say I can guarantee that there is a marriage to happen. And subsequently, if you do get the license, it is very complex, and it's like you move into medical equivalent of brain surgery instead of first aid, because there's a lot of ways that someone could take advantage of you. So it's very important from a training and development to at least cover some topics and some general caveats for those that get the license. So I like it.
You know, Marvina, did you want to jump in on this topic? We got your audio working yet?
Can you hear me now?
Yes.
Hey, first, this is Marvina calling in from the manufacturing plant for 420 Skincare. Thank you for joining us.
Thank you. Sorry, you guys. It's been a long morning and my computer just went haywire on me. But anyway, I am Marvina Thomas. I'm the owner of 420 Collections, which is 420 Skincare and also 420 Medibles. We also own 2 clinics here in Glendale, where we help men and women get off drugs and alcohol and get them back into society.
So, and thank you for joining us.
Thank you.
Will's gonna go to the slide to slide, and then we're gonna do a little round robin here. Clark, Alex, John, Jeff, Marvina, back to Will, and go ahead and get some commentary going on this. So thank you again for joining us.
Thank
Will, take it away.
Okay, so there's a slide that's out of here that was in here last week, and that's Arizona residency. So if you remember in the last iteration of the rules, in order to qualify as an applicant, you needed to establish that you had been an Arizona resident. That has been removed. So just wanted to point out that that provision is now gone from the final rules. Felony exclusions stays in the final rules. So principal officers and board members, that 51%, cannot have a conviction of one of the crimes that you see listed in 362801. It's in the criminal code in 1390103. You'd have to click on that to see what those crimes are. They're mostly violent felonies. So those are disqualifying convictions for applicants. On the other hand, if somebody has a conviction which otherwise would be disqualifying, but the offense was a controlled substance offense that was classified as a felony regardless of jurisdiction, and it was adjudicated and sentence completed more than 10 years ago, or if it was something that would have been immune from prosecution before the Medical Marijuana Act, that would be excluded. So I'm a little bit out of my depth here. So let's hand it over to the lawyer crew to shed a little bit more light on what the exclusions are and then some of the exceptions for those exclusions for the applicants.
Clark, no, sir.
Yeah, if we're going in order, I guess I'll go again.
This is the little loop. You can always pass if you want.
Yeah, so the one thing I want to point out for the audience is that excluded felony, offense it's essentially the bar to get into the industry, whether or not you're on the medical side or the adult use side. I know that, for these social equity licenses, they'll be licensed under the adult use program. But in order to participate in the industry, you have to have either what's called a dispensary agent card or a facility agent card that's tied to one of these licenses. And if you have an excluded felony, you can't get any of them. The only other thing I kind of want to point out is while the state did take out the for the social equity applicants, the Arizona residency requirement, there's still I think, implicitly an Arizona residency requirement. And I know we'll dive into this a little bit further in the next slides, but the department now reduced the eligibility criteria for a social equity person from 5 to 4, and you have to meet 3 of the 4 criterias. But essentially it's 2 out of 3, because 2 of the criteria all have to deal with, the criminal aspect of it, which we'll get into, which is either having been charged or convicted with a low level, marijuana offense, or having an immediate family member that's tied to it. But the third one, I think the most significant one that the department is not out with yet, is residents in a in a community that's been disproportionately impacted by marijuana laws in 3 of the 5 years. And I think through that, it's insinuating that whoever's applying does have to be an Arizona resident. And I want to clarify that for our out-of-state audiences here today.
Alex, do you want to go?
Yeah, the only real comment that I'd want to make on this is just that if you did have an excluded felony offense, but it was something that you could get expunged, that would be something that it wouldn't prevent you from entering. So there's a list of those, and I won't go through it now, but it's one of those things where you'd have to go to maybe an attorney and have them look at what your record is. Yes, maybe it's an excluded felony, but does it qualify for expungement? If it does, you'd be okay.
Yeah, Alex and Clark really hit on the 2 points that I was going to raise there. I think this really highlights, the importance of expungement. So, if you've been arrested for 2.5 ounces or less, and that could be a felony in Arizona, we had some of the strictest felony laws for marijuana possession. You could still get your record expunged and get into the game. And the other point I would raise, kind of parlaying on what Clark was saying there, is that there was another change to the qualifying criteria with respect to an individual who's been arrested. In the last round of the rules, it could have been a federal or state offense that occurred anywhere in the country. And in this more recent draft, it needs to be an offense that happened in Arizona. So at this point, there's a very limited class of people who could qualify and have never resided in Arizona. Namely, if they're not trying to use that 4th criteria of the geographically disproportionately impacted area, and they happen to have gotten arrested in Arizona while they were passing through or something like that. But there's going to be a residency component for the overwhelming majority of people that are going to be able to apply.
Jeff, Marvina, any additional thoughts there?
Good.
All right, just hit on mute if you want. Will, go ahead, next slide. And next time around, we'll go swing the pendulum back the other way and do Jonathan, Alex, Clark. Just so. I should have been a Supreme Court judge.
So Dimitri, you're going to send this PowerPoint out, I think, later on in the week. And if you click on these, it'll take you to the statute that shows you what those felony offenses were that are disqualifying. Okay, so let's jump into the gating criteria. So at the last iteration of the rules, you had to meet 3 out of 5 criteria, one of which was a freebie, which is the class. Now the class is required for everybody, and you need to meet 3 out of 4. And I like the criteria myself. That's an editorial thing. I think it meets the intent of what was in the statute that the voters approved. Not everyone will agree, but remember, you got to stay true to what the statute said, what the voters approved. And so let's just dive into the gating criteria. You need to meet 3 out of 4. They haven't changed hardly at all, except for the education component from what we had seen about 10 days ago. The first one is that you can establish that you had a household income in 3 out of the last 5 years of less than 400% of the federal poverty level. So that's the FPL. It's what's used in the Affordable Care Act, actually, for the subsidies. You qualify for a subsidy on the marketplace plans if your family income is less than 400% of FPL. So they use that number, same number that's used in the ACA. I like this criteria for 2 reasons. One could make an argument that maybe they ought to put it at 200% of FPL or something. I'm not going to, micromanage that. What I like is that it's verifiable. And that's going to be an important component of all these things, because there's going to be people that try to cheat their way into qualifying for applying for these things. And you've got to have measurable criteria that you can verify in order to keep people from cheating their way into this deal. And this is something that's verifiable. I mean, people pay taxes. The IRS has filings for it. It's a document that it's a public, it's something that you can prove. And so I like this one. Let's see what everybody else thinks about it. It's verifiable. That's one of the things I like the most.
Yeah, and I'd say I agree with that too. I like that it's verifiable. I think that you're probably correct. The department will require a tax return as the supporting documentation. A lot of that's still open-ended as well in terms of what documents people are going to need to produce to the department to show they satisfy this criteria. Certainly, this is something that's been done in other states. Other states' programs have looked at your income level to determine if you're someone from one of these disproportionately impacted communities. And I think there's good reason for doing that. This program is about giving opportunity to people that otherwise didn't have it. And there were high barriers to entry in previous application rounds, including the requirement of identifying property that's zoned correctly, which often requires the assistance of attorneys, number one, and having that $500,000 that's dedicated to operating the business. So I think this really allows people that otherwise didn't have a great opportunity to get into the industry to be able to submit an application. So I would concur in your judgment.
Alex?
I agree. There's not much more to say with that. I think it's good to have some kind of an income qualifier here because it is a social equity program. And so I agree.
Clark?
I guess my only comment is I'm happy to see that the department doubled the income threshold. I think because otherwise it could have potentially excluded individuals who would, meet these other social equity qualifiers, but maybe they're in a position in their lives now where they're doing a bit better financially and they still want to give back, but now the income barrier prevents them from doing so. So I think it's a good thing that the department doubled it.
Marvina, Jeff, you want to jump in on this one?
Yeah, I was just going to say, I totally agree also.
It's verifiable. That's what I like about it. And as we talked, we can argue about the percentage, but it's a good number.
Yeah, I totally agree.
Yep. It matches right up with the ACA, which the Supreme Court's going to be ruling on in the next 3 weeks, by the way. Second criteria, previous marijuana conviction. So this is if you, as the applicant, and now this applies again to all the principal members and principal officers and board members in that 51%, not all of them, I think, and let's let the lawyers talk about that. I don't think it could be one of them. All of them that make up the 51% need to meet the 3 of the 4 criteria. And here's the second one, which is a previous conviction of a lower level marijuana offense, possession of 2.5 ounce possession, transportation, blah, 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 of 2.5 ounces, or was convicted of a violation of federal state marijuana paraphernalia laws in another state. So let's talk about this a little bit.
Yeah, so I think this is one that, is a pretty clear-cut thing that should be in here. And this is a feature of virtually every social equity program, or the overwhelming majority of them, allowing people to qualify if they've been arrested for a marijuana offense. And that, goes to the purpose of the program, which, although it's vague, as Dr. Humble pointed out, it's just supposed to promote the ownership and operation of marijuana establishments by people from disproportionately impacted communities. I think this is one really clear-cut way to do it. I guess my one maybe concern, I'm not sure exactly how I feel on this yet, is that you need to have been convicted in Arizona of a violation of federal or state law related to marijuana. And I think there are some people that have moved here recently that arguably should qualify for the program, but they would happen to have been arrested before they moved to Arizona, and they're now going to be excluded as a result of the location of their arrest. So I think there's probably some people out there that are going to be displeased with that revision of the rules, but really when it comes down to it, social equity is incredibly difficult. And I think no matter what decision the department made on how the rules looked, there were going to be some people that were unhappy, because it seems no matter what you do, if you try to keep out people that shouldn't be getting in, you're going to be excluding some people who should get in. And it's kind of a give and take. So the department really finds itself between a rock and a hard place on a lot of these issues. But that being said, in general, I think I'm very pleased to see this being one of the qualifying criteria. Although I will say in other states, it's often like if you check off that box, that's all you need to get in. In Arizona, we have, I think, a fairly restrictive program insofar as other states have gone. But that being said, I'm pleased to see this in the rules.
Just piggybacking on that, one comment I'd want to make is just that for the petition for expungement, keep in mind, you don't have to have a conviction to be eligible to petition for the expungement. It's a very broad statute. It can be a charge, it can be just an arrest, or they use the word adjudication also, which is just very broad. But in my mind, I just think of charge and arrest, really. So don't, if you don't necessarily have the conviction, but maybe you've been disproportionately affected because of an arrest in the past, that would still qualify you as long as you meet some of the other criteria in that statute.
Clark, anything? Pass?
I mean, I think John and Alex covered most of it. I do want to answer Dr. Humboldt's question, which is, whether or not everyone who's part of the 51% have to meet the, have to meet these type of disqualifier. And I would say yes. The only other thing is, and I just want to confirm that I'm remembering correctly before I make the statement, but something, piggybacking off of what Alex said, and we might be moving to the section next, but there's a difference, I think, in this section, which talks about, expungement. So the individual applicant could qualify by, having been arrested and charged but not convicted. But in the subsequent section, when it's talking about having, qualifying through an immediate family member, that one has to be a conviction. You don't see the expungement language. You don't see the charge and arrest language. If you're trying to piggyback off for somebody else, that individual does have to be convicted.
Yeah, yeah, definitely. Yeah.
Jeff or Marvina?
No, it is a great point. I think that the lesson here really is, if you qualify, I think you qualify, that preparation, getting your paperwork together, identifying, getting with counsel so that you can move through the process. There'll be a lot of very panicked people, I think, in October, November, if the preparation isn't considered soon.
Yeah. Start these things early. I mean,
Yes.
expungement proceedings, they can take, sometimes they're quick, sometimes they take longer. And if everybody's, burdening the court with all these petitions, it's going to take longer. So you want to start that process.
Marvina?
And I'm totally agree. I'm just listening to everything they were saying. Yes, I'm totally agreed. We definitely need to get started early. You have to get started because something left out.
And at the end of this seminar, if you guys each want to give your own suggested recommended timeline for individuals out there that might watch this webinar over the next week or so, because I think that, the New Times, Arizona Republic, this is unbelievably helpful information, and it should be shared throughout Arizona. We have Dr. Humboldt, 3 of the top attorneys, 2 top industry experts. So let's hope we get this out more and more. But yeah, we should give an example of a idea of people, what they should be doing at what points in time over the next 6 months. Sorry, back to Will. Next slide.
Okay, next gating criteria, we've touched on it already, and that is the relative's conviction. So, and again, you mentioned it was arrest and stuff on if it's you, but you can also use one of your criteria if you have a spouse, surviving spouse, parent, child, sibling, guardian. It's in the rules. You could look at the list. Who was convicted for a violation of federal or state laws related to marijuana paraphernalia. I think I'll leave it to the lawyers to talk about the details of what qualifies under this gating criteria. This one looks to me to be one that might be a little more problematic to verify. And it has, I think, more opportunities for people to cheat their way into meeting the criteria. Maybe that's not the case. It's, explaining who your spouse is, families are pretty complicated sometimes. And there's some gray areas in some of these definitions. And that may be an area where at least I hope the agency is going to be very clear about what they expect you to submit for this criteria and how they're going to verify it, and that they will be diligent about looking for people that are trying to cheat on this one.
Yeah, I'd make, I think, 2 points on this. The first of those is to contrast this with the last provision that we looked at. This encompasses a much broader variety of marijuana offenses. So there's no limitation about excluded felonies for this. So you could have a parent, child, etc., who has been arrested for possession with intent to sell, a felony that can still be a qualifying offense, again, so long as it's happened in Arizona. And then the second point I would make to address a point that Dr. Humble raised is that I do think that this criteria in particular could be open to kind of creative ways around the rules. So for example, if you look at child, some of these are, as defined in various sections of the administrative code. Child, it just says child. And I wonder, I haven't heard of anyone thinking about doing this or not, but I'm wondering if there might be people out there that they're looking at this list of criteria. They desperately want to apply. They know they qualify 2 of the criteria, but they're short on the 4th. And I wonder about like an adoptive child, if that qualifies. After you go out and you adopt a child with an offense, I mean, you meet that provision now. I don't know if anyone's going to do that or if the department would allow it, but it seems to satisfy the text of the rules. So it's,
Yeah,
I think, open to some creative maneuvering.
I wouldn't disagree with that at all. I would just add that it also seems like it might be a way to get around having to go through the petition for expungement. If you have a conviction, you want to apply, but you don't maybe you're late to the game for the expungement proceedings. You can't go that route. You could have a spouse apply and they could just qualify. I mean, again, you'd have to have the conviction in this case, like Clark was pointing out, but it could be a way to get around that late in the game.
Clark, Jeff, Marvina, any comments before Will goes to the next slide?
My only comment is, I know everybody's been talking, everybody's having the cynical view as to this criteria, but I kind of like it. I think, it opens up, it makes it generational, right? And it opens up the ways for kids of, individuals that might have been impacted by these laws to really have this opportunity and give back to their communities. And I don't think that's a bad thing. I was actually happy that the department added in this expansion to the eligibility criteria instead of limiting it to yourself personally. So.
I agree with you, Clark. I agree with you. I think it's a good thing to include. My challenge to the department is to make it clear about where the bright lines are with these relationships, because I want this to be true to the real social, who this was really intended to be. And there's going to be people trying to get through the doggy door in the backyard on this. And you got to make sure that you're clear. So it could be that we see another iteration of the rule, or what agencies call a substantive policy statement, to give a little bit more definition to what these relationships are, because it's going to be, I think, for the integrity of the program, it's going to be really important for the agency to be able to clearly identify and verify those relationships, that it meets the intent of what they had written in the final rule. So I agree, it's a good one, but good with verification, because otherwise you're opening it up to somebody, trying to squeeze in the door that really, doesn't meet the full set of criteria.
And if there are any changes like that, we will get them out to people on our email list as quickly as possible.
The last one of the 4 criteria is something that we saw 10 days ago in the second to the last iteration of the rules. And that is that the person had lived in a community disproportionately impacted by marijuana laws. They need to show that they lived there for the 3 of the last 5 years. The kicker here is that the state has not defined what that is yet. The last iteration of the rules said they do that by September 1st of this year. I didn't see that date in the final rules, so I don't know if they have a goal for defining where these geographic areas are. I do expect them to put this out as geographic areas, probably if not census tracts, zip codes. It could be that they use remember the CHAs we used for the medical marijuana, that could use, those are also called primary care areas, or PCAs. Could be PCAs, primary care areas, could be a CHA, could be a zip code, could be a census tract, but look for it to be geographic. And then again, key here is to keep this fair. I mean, you're the umpire at the agency at this point. You know, you got to make sure that the strike zone is clear. What's a strike and what's a ball? And the more clear you have it, the fairer it will be for people. And what they need to be able to do is be able to have clear criteria so that you establish that you actually lived there, like it says in the final rules, and that you didn't just have an ex-spouse that you were paying child support that lived there, for example, and you paid the utility bills, but you didn't really live there. So this one's a challenging one, and but I think it's good. So I mean, I think it's good. But it's just that if I was at my former agency, I'd be challenging my staff to figure out ways to make these really bright lines.
Well, just the word has lived is very subjective. I mean, you know, residency, lived, are you know, some voter registration, gas bills, you know, physical presence. It's very vague.
Right, and they're going to have to do that. They're going to have to put out, when they put out the September criteria, if it's in September, they really need to put some more boundaries around what verification documents that are they going to take a utility bill? You know, is it what property tax? Did they rent from a landlord? Can they show the receipts? I mean, they're gonna have to establish what those are, because these are multi-million-dollar criteria we're talking about here potentially for a successful applicant that really does well.
Clark, any thoughts on this subject?
I mean, I think we've touched upon this quite a few times already in the previous panels.
Okay.
In my opinion, it's the most significant criteria right now, because it's going to determine who's going to be eligible. Because, you know, regardless if you meet the income or have you meet the, you know, criminal aspect criteria in one way or another, if you don't live in one of these areas, you can't qualify. I think, you know, in keeping with the social equity aspect of these licenses, and looking at what the department has done in the past, I think they might try to do something that's similar to CHAWS, but, you know, but aggregating different objective statistics and criteria that they could use to base off of why, you know, or how they're coming up with these disproportionately impacted communities. Do I think it's possible that the department, you know, will look to, or can or will look to zip codes? Maybe, but that might not capture, you know, as many of the individuals or groups that might otherwise be eligible for this program. So, I mean, it's really, we'll see. You know, on the September 1st deadline issue, I think that the state is probably going to try to meet, you know, the deadline that they set for themselves in the last of their draft rules. I think the only reason why it's not in this one is because it's the quote unquote proposed final, and the notice of exempt rulemaking has been made. And, you know, we've been talking about documentation a lot throughout this panel, and I think it'll be interesting to see when the department actually comes out with what documentation you need to substantiate all of these things, because that was also a note that they left in the last of the draft rules. You know, they left that open, saying, you know, we'll come out later and actually set forth exactly what you'll need to provide in order to meet these requirements.
Alex or John?
The only thing I would say is, Dimitri, kind of like you said when you were looking at this, that word lived jumped out at me too. You know, as a lawyer, words are really important, especially when terms like residence or domicile, those are things we look at. They have different meanings, and it's important which words we use. So something like lived, I don't know what that's going to mean. I mean, that's not defined separately in any other statute in Arizona that I know of. And as I'm sure as Jonathan and Clark would say, residence and domicile are things that are defined in other statutes. And so it does leave it pretty wide open. And I'm interested to see where they land on that.
Yeah, I would say as a first comment, I was really happy to see this get added to the rules. I think it's the best thing you can do to really further the intent of Prop 207, looking at communities that were disproportionately impacted. And in the first draft of the rules, of course, it was just based on your income level and whether you've been arrested. And I view that as more of a set of individuals that are disparate than an actual community. So when you're looking at these geographic areas, I think you're doing a good job of making sure you're really focusing on the people that should be helped. And that's one reason why this approach has been adopted in many different locations in Massachusetts, in Chicago, all over the country. And I agree with what's been said so far. I mean, first of all, lived is incredibly vague. I mean, what if you live there, for part of the year, but you have another house elsewhere, and that's where you primarily live? Do you satisfy that condition then? I think that's very unclear. It's unclear what kind of documentation you're going to need. Then, of course, there's the very big uncertainty of which communities and which geographic areas are going to qualify, which we'll find out September 1st. There's zip codes as a possibility, which was raised. There's census tracts, which has been raised. There's police beats, which has been done in, I think, Illinois. So there's a lot of different kind of breakdowns of geographic areas you could look at. And then there's the other question of what criteria will the department use to determine which of those zip codes, census tracts, police beats, et cetera, qualify? Are you going to be looking at, where arrests occurred? Are you going to look at, low income areas? Are you going to look at marijuana arrests in particular? And that's another thing that's been done, differently around the country. So I think that the implementation of this rule is going to be interesting. The devil's often in the details. And then the question of supporting documentation, that's also a very open question. What you're going to need to show the department to prove that you satisfy that condition. And in the last round of licensing, that was an issue that really became unclear with respect to the supporting financial documentation up until the very end of the deadline. Whether you needed to show a bank statement, if you get a letter from your bank to show that you had the $500,000 in funds. So I'm hopeful that this time around there will be a little bit more clarity on the documents that need to be provided. And I noted that was also one of the comments in the last draft of the rules, is that there'd be some more clarity on that, but I didn't see it in this final draft. So hopefully as we get closer to September 1st and the application deadline, there will be some more information and to give people a heads up about what they need to do to make sure they submit a compliant application.
Jeff, Marvina?
I agree with what's said. I believe this is one of the more important parts of the social equity program. I also agree that the difficulty here is what I consider disproportionate is not the same to you or the next person, and the criteria as defined by the department is going to be extraordinarily difficult. I don't wish that on anyone.
Marvina?
Yeah, I totally agree also. Nothing more to say. I just agree with everything he was.
Well, we have a quite insightful panel, so they're
Yes,
a good group to agree
indeed.
with. Yeah, and if anybody wants to know, I know the definition of everything. So I'm just kidding. I was gonna make a joke, but it's gonna be too political. Anyways, back to Will.
I'm just going to say, really kudos to the agency for leaving this one in there. It would have been easy for them to exclude this and leave it out because it's a big, giant gray area. It's fraught with conflict because there's going to be conflict at the end of this, for people who believe that they met that criteria or they didn't meet it, or the people say they cheated their way into the lottery and this kind of thing. But they didn't shy away from it. They did it anyway. And I think it's important because it was the true intent, the 207. And I don't know how you meet that true intent without this criteria. So my hat's off to them for not, backing off, because doing the right thing often means doing something harder than you could otherwise have gotten away with. So
just a real quick question. Is there something that DHS is familiar with that which they might lean on? I know you mentioned Sean, all these other things, but did you ever see this as a director where this?
Well, most of what we do in the state health department has to do with health outcomes. And so for us, the primary care areas are PCAs, which is a HRSA, the Health Resources Service Administration. It's part of Health and Human Services. HRSA has these PCAs, which we call CHAs, but it's the same thing. And that's got like the percentage of people on Medicaid. It's got, there's a host of social determinant criteria and aspects to PCAs. They're posted on the state health department's website. One of the reasons we use, by the way, in medical marijuana PCAs is because there was it was 10% of the number of pharmacies, right? Which at the time was 126. And we coincidentally had 126 CHAs. So we're like, perfect. Why would we not use CHAs? So that's when the light bulb went on for me. I remember I was in the elevator at work and I'm like, wait, we have 126 CHAs. So
some people were suspecting that you were trying to save some for the tribes.
And at which match if the tribes have their own jaws.
Yeah.
Yeah, that's right. So I was in a way. So I don't know if they'll use PCAs, if they'll use zip codes. You know, here's the thing is that, you know, I hope what they use is that they look at arrests and convictions for that subset of marijuana crimes under 2.5 ounces. You know, that should be the core thing that they're looking at, because that was the true intent of 207. That's what was expungible. 207 didn't talk about the big transfer stuff, you know, the big amounts of previous convictions for stuff where it was pounds and pounds of it. So I hope they look at just marijuana, but that's just, I'm speaking just for if I was in my old job, which I'm not.
Well, but there are other ways also that a community has been disaffected. So I get back to how they are going to define this, because a community may be suffering economically because of maybe the arrests aren't happening in that zip code, but they're getting the splashback from the effect of it. So it's going to be very difficult.
If they go that direction, I think they'll use PCAs. Because that data they've collected it, they have it. Let's say they're going to use percentage of Medicaid qualified persons in that zip code, let's say,
Right.
or that PCA. So I don't know what they're going to do, but I'm glad. But my point is, I'm glad they kept it, because it would have been easy to chicken out and say this is too hard, but they kept it in. So my hat's off to my former team there. All right.
Next slide.
So there was something in the chat box about, is it 3 out of 5 or 3? It's 3 out of 4 now. It's 3 out of 4 of the criteria that we just went through. I'm not going to spend a lot of time on this because it's exactly the same as it was last time. And this is for the protection of the applicant so that you cannot get pushed out, basically, of your team. If you're on the 51%, you get to stay in the 51%. They can't do like a Survivor episode thing and kick you off the tribe. You're in, and you have to say you're out. You have to say, I want out, or a court order has to move you out. So, let's opine on this one then.
Clark.
My only comment is, and it's semi-response to the question that was in the chat box, which is, you know, we talked about this a little bit earlier. Does everybody that consists of that 51% have to meet three out of 4 of the criterias? And the answer is yes. And I think the answer is yes, because there's additional protections like this for the social equity candidates, after licensing. So because you have the voting right protections, you have the non-removal protections such as this, because you have the financial limitations, the state does require everybody who's applying to meet, if you're part of that 51% group, to meet 3 out of the 4 criteria.
John or Alex?
Exactly. Yeah. I mean, the idea is we don't want someone to get into the social equity program and then just be able to be kicked out without their own consent. And I think I said this at the beginning, but there's ways that you can draft operating agreements for companies where there's triggering events, and someone, even if they have 51%, they can be removed without their consent. So I think the department was just trying to have that foresight and say, we want to make sure you have the 51%, that's your voting rights, that's your profit distribution, and it can't be taken away from you unless you voluntarily allow them to do that, which would probably be through a sale or something like that. And so I think it's good. I think it's good to have.
Yeah, I don't have much to add here. I think it's a real credit to the department. They've gone so out of their way to try to make sure they're cutting down on predatory arrangements that have happened in other states by having provisions like this, and also trying to cut down the costs that are needed to submit an application. Whether the $5,000 fee is appropriate or should be refundable or not, that's kind of an open question, but getting rid of the property requirements, getting rid of the capital requirements, I think makes it even easier for people to just even go through this whole process without needing to necessarily partner with others. Some may want to avoid the $5,000 risk. That's a separate issue, but the department's really, I think, gone way out of their way to try to stop people from getting taken advantage of, and give them credit for that.
Well, there's no shortage of individuals looking to put up that $5,000. I mean, we get contacted by them, and it's a fascinating process. But let's see, Jeff, Marvina.
Well, Dimitri, one thing I was going to mention is if you have more than one person who meets the criteria, for goodness sakes, put in 2 applications. We don't want to waste all those qualified applicants on one application. But we also have a limit on the number of applications that a person who meets that qualification can be on, I believe. Isn't that correct?
Yes, it's 2 applications, which is actually kind of interesting to me, since for every application process up to this point, everybody could submit up to 5. So why limit this round to 2 applications per person? But it's kind of where we are.
We'll have to find out. Marvina, any thoughts on this last slide?
No, they already answered. They was gonna say they already said it. I'm in totally.
We're good. Will, next slide.
Next.
You're on mute, Will. I'll just sing a little song.
Yeah, okay, technical error there. I'm not doing bad though.
No, you're on it today.
I'm sharing screens and everything.
Yeah, you're moving.
So application limit, we just talked about it. And I don't think there's a whole lot more to add on that. Or maybe there is. It looks to me like that you could do 2. But here's a question I have, and maybe you can answer this one. Let's say you are already a principal, owner, officer, or board member of a adult use thing establishment that's already existing. And does that count as one of the 2?
I don't think so. I think this is just because they cite to the specific provision that authorizes these applications in the rules. So when they're talking about you're limited to 2, they're just talking about submitting for social equity, I think.
Yeah, I would agree with that. I'd also add, the way I'm reading this is that, and I kind of want to see if the other lawyers are seeing the same thing, but I'm reading this to mean that that limitation is for any principal officer or board member, not just the qualifying applicants that are making up the 51%.
That's a good point.
Yes. So they
That
got
sounds
rid
like
of
it's
that.
worth saying again.
So we have a portion of this that, and I use the word qualifying applicant, that's not something from the regulations, but when I say qualifying applicant, I mean those applicants that meet the social equity criteria. We're talking about disproportionate community, income, all of those, they meet that criteria for the applying entity, right? The way I read this is that not only do those 51% principal officers and board members, they can't be on more than 2 applications, but also the 49% principal officers and board members that didn't have to meet those social equity requirements. I read this to mean that limitation also extends to them as well. Does that make more sense? Does that clarify?
Yeah.
Yes.
Okay.
That sounded really important to me.
Yeah, and that's
I try
different
to
from the
sound
last round.
important. That's my goal.
Yeah, I would note too that that's a change from the first set of rules that we saw, where there was a different application limit for the qualifying people and for the non-qualifying or potential funders. So a lot of people were unhappy about that, allowing the funders, partners to submit more applications than the qualifying people. So I think this was a good change to make sure everyone's on a level playing field.
I agree. Okay, now here, this is so we're done now with the criteria and the limitations. So let's move on to something else, which is, this is a new thing, and I think it's a good one, which is, what is your obligation as a community benefit licensee after you win the lottery? You apply, you get into the lottery, you win the lottery, you execute, you get your establishment up and running. You have, under these rules, you have more obligations and responsibilities than a regular marijuana establishment owner, and that you need to show that you will, how you're going to help communities that were disproportionately affected by marijuana laws. And the rules outline 2 specific ways that you can establish how you're helping. Number 1, and I think this is good, honestly, specific hiring and interning practices at your establishment. So what are you going to be doing something to help out people in your community to give them an opportunity to work in either your cultivation or your dispensary or all the other jobs that are associated with a retail store, or I guess you could say a donation of a percentage of gross profits to focus on social and health inequities in your community. Sadly, I put this in parentheses here at the bottom, they didn't say what that percentage is. So I'd love to see that be, say, 10% or something, but it doesn't say. So it could be, unless they change the rules. I can see what you guys think. Y'all think if it looks to me like it could be 0.005%.
Just
The second one.
let me have Marvina speak first because she has to drop off. Marvina, do you have any thoughts on this slide and this issue that Will brought up? I know you have to drop off for a meeting right now.
Yeah, I do. So thank you for asking. But anyway, I think that is a good one for them to give back to the community, for all the nonprofits that are out there, because I know that it has not been done for some people that has, and you know, like me, I am a nonprofit for one of my businesses that I do have, and I do have some of the dispensaries do help out giving back to our community that we are servicing. So I think that's a very good one.
Well, and thank you for joining us, Marvina. I know you have to drop off to a meeting, but we'll see you at the next panel discussion.
Thank you for having me, guys. Much love.
Clark, Alex, and Jonathan on the same issue.
We kind of talked about this before, but you know, I think the department put this in here as a way to maintain the quote unquote social equity, you know, aspect of these licenses, even after a potential voluntary sale by the, you know, by the license holder, which I think, you know, it's a good thing. It's in keeping with the intent of the act. Something that I was actually personally hoping to see was, you know, having this type of requirement, but added in as part of the application eligibility criteria. So for example, you know, instead of, we could still keep it 3 out of 4, excuse me, not, you know, 3 out of whatever number, but maybe the 5th criteria could have been, you know, an individual that has historically demonstrated a commitment to one of these communities doing X, Y, and Z. And I think that would have opened up the pool a little bit. I know we're a little bit late for that, but just some food for thought.
Yeah, I would echo what Clark said there. I was really hoping to see this be one of the qualifying criteria for applicants. And that's something that's been done in other states too, like I know in Oregon, I want to say Illinois. So there's some precedent for that. But that being said, I am really happy to see this being included in the rules. One of my concerns with the initial drafts is that the program would result in some big paydays for isolated people from these communities. But in my view, the intent of Prop 207 was to make sure communities had some kind of a long-lasting benefit from legalization, because they've been so harmed by the enforcement of our prior marijuana laws. So I think this goes a fairly big way towards doing that. I would have liked, as Dr. Humble said, for this to be strengthened and there to be a little bit more certainty in it. So for example, there's no, as Dr. Humble said, there's no set amount that you need to donate. There's no set amount of people that you need to hire. And you don't even need to do either one of those things. The rule said that you had to implement a plan for benefiting the communities, such as one of those two things. So you would still be free to do something entirely differently. And it's unclear what the enforcement's going to look like on this. So I would have liked more certainty to make sure that people are really going to follow through with this in a meaningful way. But that being said, I'm certainly happy to see there being some kind of long-lasting benefit to disproportionately impacted communities.
Somebody in the chat room says, Sandra says, so for social equity, those that have been marginalized are charged with doing more for their community than the other businesses. Those who have been benefiting from marginalized people and currently owning their businesses are not held to the same standards. So where's the equity of that? Oh, the world.
That's a good point. That's a really good.
Yeah. That is a fair point. And I think it reminds me too of the debate over whether these licenses should be transferred or not. And when you prohibit transfers, you arguably aren't doing the community you arguably aren't doing justice to the person who gets the license, but if you allow transfers, you arguably are hurting the community in the long run. So it's kind of this delicate balancing act, and I don't know that there's any real right answer to how you go about doing that.
The difficulty I have with it, with this community benefit, Dimitri, is that it just says show how they will help. And as has been pointed out, does that mean throw a couple of paragraphs together? Is that a check the box and now you go into the lottery? You know, we don't want to over engineer this section of the application. Obviously, we want to be very attentive to the community needs, but they've left it a little flat. And I think a couple paragraphs might qualify for what they're asking.
Well, Mita will provide a couple paragraphs to anyone that wants them.
There you go.
Yeah,
Yeah, it's, it is all about enforcement in the end, because this is a post-license requirement.
Right.
I mean, Will, the Prop 20, what is it, 203, the first one, the MMA said they're supposed to be not-for-profits, but nobody enforced that. And
not only that, it said it like 103 times.
yeah, and we all know that they've been being sold, that courts.
I know. I put a thing in the rules that said these licenses cannot be transferred. Go look at the rules.
They're not.
Well, they're getting around it. I didn't do a good enough job locking the door.
We know.
Anyway, let's move on.
Okay.
I wanted to stay true to that nonprofit thing, but I failed miserably.
We should move on.
All right. Applications are accepted the first 2 weeks of December. The fees are $5,000 per application, non-refundable. The folks that qualify, that the department determines qualify, will conduct a random selection, and the 26 will be selected, and they're required to issue the licenses by the end of the month because they finished the rules at June 1st. Now, there's something in this timeline that I want to really talk about, which is think about this. The applications are due between December 1st and December 14th, and they need to do the Keno Ball selection between Christmas and New Year's. That leaves them
2 weeks.
About a week to 10 days around the holidays to verify all of the stuff we've been talking about. Verify the relationship that you had. Let's say your spouse was convicted of a marijuana crime. The address that you turned in for that you lived in a community over policed. I mean, they're going to have 10 days during like when everyone's taking time off. They're going to have only 10 days to verify potentially. I mean, how many do you think are going to get? There could be 300, 400, 500 applications coming in. And that means probably maybe as many as 15. If that's true, you're looking at maybe, let's say 2,000 principal officers and board members in the 51% that you've got to verify that that's their uncle.
Well, could they at this point just say, we're going to accept everything on face value, but
that's what they'll do.
Subject to audit.
What they're going to do probably, and this would be a smart thing to do, is to require that each applicant attest that everything there is true. And if they find out in February that you lied and that wasn't your uncle that had the marijuana conviction, then your whole application is disqualified.
But is that like an internal decision, or does that have to be in some sort of rules that they lay out?
That would be on the application form that you file.
No, but like do the attestation subject to audit, your license won't be issued until it's audited.
That would be in the application.
Okay.
Like when you apply to the department, there's going to be an application form, and I guarantee you they're going to have, well, I can't guarantee it, but I'm pretty sure they'll have an attestation in there that says, I attest that everything in this is true. And I further understand that if this is a false attestation, that this application will be null and void, something like that. But I am concerned that there's only 10 days for them to verify this stuff. And so I just wanted to open that up for discussion.
Yeah, I think that's a really good point. With the last application round, it closed on about March 9th, and there was a little bit over a month before the lottery actually happened. And for folks that haven't submitted an application before for a license, usually the way it works is you submit the application. If there's any questions, the department will submit a request for information. You can kind of go back and forth. And there's the possibility for informal settlement conferences, and that just takes some time. So I'll be curious to see how that plays out in such a narrowed time window. But I think Dr. Humble raised a great point about the attestation and the audit. So very interesting.
Guidant or Clark?
Yeah, I don't know how that attestation and audit would work, to be honest with you, because it gives them a hard deadline to issue the license on the 31st. So it's not as if they can hold the license back after the 31st, do an audit, and then if you qualify, later on they have more time to review and then issue. I mean, the way I'm looking at it, I guess under what you're saying is it could be they issue the license on the 31st, audit, and then if you're, weren't in compliance, they retract the license, and now the department's holding all these, they could be holding a handful of licenses that they retracted. So I guess there would be another round to issue those licenses. I don't know. I guess what I see what you're saying is it might be the only way, but it seems really inefficient and time consuming. But I mean, these are the dates they set for themselves. So I don't know.
Well, but also let me say this. I'm not a lawyer. You guys are. They finished the rules on June 1st, and the statute says they need to issue the licenses 6 months later. But remember, they have exempt rulemaking in perpetuity till 2025. They could say that these are here's, for example, maybe they could say that when they put out the September rules that identify the geographic locations of and I hope they do this, quite honestly, the geographic locations rule making is the final rule, and that's September 15th, let's say. Now we have 6 months to issue the licenses, but the applications are still due December 1st through 15th. Then they have actually some staff time to hire some accountants and lawyers and detectives to verify the stuff. That's what I hope happens, because if you just compress this into, that's one of the things that really I was most nervous about when I saw the final rules, is that 10-day window, because maybe I'm an administrator. It's like, I have 10 days for hundreds of people telling me about their uncle who got a conviction and where they lived. And is that the real property tax for me, or was I paying my ex-wife's property tax? I mean, so I don't know what to say.
Yeah.
I hope the final rules are really the September rules, and then the licenses are issued in like March or April. It gives them a lot more time to get it right.
Me too.
All right.
And who knows? Maybe they're actually listening.
Next slide. Hey, this is a
We
great
hope
show.
so.
I mean, this is some good stuff. Next slide, Will.
Yeah, I'm almost done.
All right, we'll leave some time for commentary at the end.
The final rules are here. I did add one slide, which I want to talk about because it's really important. By the way, Ryan Randazzo from the Arizona Republic, who, by the way, we all have to thank that we've got a journalist that's really interested in this industry, that's thoughtful and does good research and writes good stories. And he had one in the Republic either yesterday or the day before about the expungement, which is a really important way to get the word out to people with previous convictions that, the time for they can start applying for expungements right after the 4th of July. They need to get ready and start. The link in here is on that, the third bullet here, AZ Courts. There's a link to it. I think it's really important for people to take advantage of that opportunity and get these previous charges expunged. And lawyers, you guys could talk about what that really means. And actually, Ryan's article in the Republic did a really good job of explaining what the expungement really means, on who gets to see that. Is it that previous conviction? Can future employers see it, which they can't, and how that's all controlled. He did a nice job talking about that. But I thought it was important to add this in, because it's important that all of us do the kind of outreach that needs to happen to get people to really do the work to put this expungement forward, because it can really improve your opportunities for the rest of your life to really make it on it, to make a living and have a lot more employment opportunities. And just as an editorial comment on my part, the thing that made me most enthusiastic about the initiative was not having a bunch of retail stores that converted off of the dispensaries, but the criminal justice reform aspect of the thing. That's what was really important to me as a public health person. And furthermore, the expungement provision, which allows people who had these previous convictions to get that off their record and allow them to really participate in the economy more fully, because there's so many exclusions that happen in workplaces because someone had to check that felony box because they had a joint, which is ridiculous. And it's a big cause of bad public health outcomes. It's called the social determinants of health. When you've got a conviction like that, it really hurts your ability to make a living from that point forward, which hurts your ability to buy healthy food, to live and invest in your kids' education, and a whole host of things. So that's my soapbox. Let me, now, what am I doing wrong? Stop screen share. I did. What do I do now? I put you back to you, Dimitri. I'm done.
No, you're on. I think. Yeah, you're good. Clark, Alex, Jonathan, Jeff, you want to comment on what Will just said?
Yeah, I mean, I'm not a criminal law attorney, but to the extent that you're eligible, you should definitely do it starting on July 12th. I want to point out that this is something that is special because expungement from a criminal law perspective is not something that's ever existed in Arizona before. Previously, if you have any type of criminal conviction, you might be able to get it set aside after a certain amount of time. And what that means is the state will go back and they'll change your guilty to a not guilty, but it'll still show up on background checks and things of that nature. But now with expungement, whether or not you were charged, arrested, or actually convicted, and as long as you qualify for the expungement, conditions, everything goes away. So to the extent that you are eligible, this is something that you should definitely pursue.
And yeah, I would agree with that. This is a really big deal with Prop 207. With Arizona Normal, we made like 60,000 phone calls about Prop 207 and spoke with a lot of people who either themselves or a family member were dealing with a conviction on their record. And that has a lot of effects on their lives, like Dr. Humble was saying, and not just employment and health outcomes, but getting access to housing, having public licensing opportunities. And these things follow you around, for a lifetime. And it's an incredibly big hole to dig out of. So I think it was amazing that Prop 207 didn't just try to focus on changing laws in the future, but also included restorative justice components like the expungement provisions. So to that end, we're going to be holding expungement clinics in partnership with dispensaries throughout the next couple of months. We've got one with Copper State on June 19th, one with Green Meds down in Tucson on July 3rd. We're working with some other dispensaries to do more of them. We really want to make sure this is something that's easily and cheaply accessible to Arizonans all across the state. And of course, if you're looking into applying for a social equity license yourself, it's great to get a big jump on that now instead of waiting until the end. Expungement should be a pretty quick and straightforward process. You file a petition with the Supreme Court or with the Superior Court or Justice Court, and within a short period of time, the prosecuting agency can decide if they want to go for a hearing or not. And within a month or two, it should be resolved. But I would urge everyone to just jump on that as soon as you can and try to take advantage of those really great benefits that are being provided by Prop 207.
Alex?
Very well summarized. I would just say, remember, timing wise, you're at the, it's not up to you. You're at the beck and call of the court and the prosecuting agency. And so when they receive, on July 12th, all of these applications, and as July 12th starts to approach December, it's only going to be more and more. I think the time frame is going to get longer. And so the earlier you start, the better. I mean, you don't just get in early and start early. It's really smart to do.
Excellent. Are we done with slides, Will?
Yeah, we're done with slides. I just want to thank a couple of my former team members out there at the department. There's a guy named Tom Salo, who's a smart, talented guy. You're not going to see him on the news because they only let Kara talk, but the guy's super talented. He's really smart. And he's a lot of the reason why we're pleased with the outcome on this. I know that he's been diligent and paying attention to the details. There's another guy at the agency named Rob Lane. He runs the admin council and rules part of the agency. They're the ones responsible for all the rulemakings. Also a really good guy, true to the mission of the agency and the intent of the voters. So there are other people on the team there, but I wanted to really just call those two out personally, because I think they did a great job with this. And, this thing could have been a train wreck, and it's not perfect. Probably you could talk to 1,000 people. Not everyone's going to say it was perfect. And like Jonathan said, that in public policy, that almost never happens or never happens. So kudos to the agency. Good job.
Well, that's excellent to know, Will. And so at this point, I'd like, is there a topic or a theme that wasn't discussed that Clark, Alex, Jonathan, or Jeff, that you guys want to bring up that jumped out at you that Dr. Humble might have missed in his presentation? And if there is, we'll jump right into that. Is there anything that jumps out? And if not, we can go to the next subject.
I think we pointed everything out during the slides.
Yeah.
Yeah.
Well, that's awesome. Hey, Will, you did a good job. So well done.
We're very grateful to have Dr.
Yeah.
Humble as part of the team.
You know,
Absolutely.
and the community should be grateful. And I hope this video gets shared across Arizona so people can get an initial understanding of what's going on before they reach out to their attorneys and say, what the hell what did I just watch? What just happened? So thank you so much, Will, for participating. The next subject, timelines. What would you advise people to do now and do next? Who wants to go first on that one?
Yeah, I think the first big piece, really, if you're going to be someone who's a social equity eligible person yourself, is to file your expungement petition as soon as you possibly can. There's going to be, again, a lot of opportunities to get, free advice with respect to that. There's no filing fee. Just get that done and out of the way. So that's the big first piece. I would say too, if you're someone who's looking to partner with someone who is social equity eligible and pay the $5,000 fee and assist them across the finish line, I think it's a lot, even more important for you to get a head start now, so you can start, identifying people and sort of feeling out if it's going to be a good relationship for you, making sure to the best of your abilities that the person you're speaking with is going to satisfy the criteria that we've discussed during this discussion. So those are my first thoughts on the timeline right now.
Excellent. Well, those are great thoughts. And then prepare for your closing thoughts, but let's move over to Alex. Any timeline thoughts and then closing thoughts?
Yeah, just start soon. There's no reason to wait. I know December seems a long ways off, but every time I go through an application process since the Medical Marijuana Act came out, it's always a race, and something like 6 months feels like a couple days. And so start early. Like Jonathan was saying, find your partners or the people that you're thinking about working with. Start seeking out professionals that you might want to help you along the process, because they're going to also be getting a lot of calls and people interested. And so starting that process early, developing that relationship is important. And they could don't enter into any contracts with people, sign anything without at least having an attorney take a look. That's always my go-to advice. Yeah, start early.
Clark?
My only tiny tidbit to add is keep an eye out for the things that are still outstanding in the rules. One, keep an eye out for what documentation you'll need to submit, and once that's out by the department, start preparing everything early, because that's going to be critical to whether or not your application passes muster. To keep an eye out for the definition of community, because then you'll really know whether or not you are you're eligible to apply. And 3, keep an eye out for the the educational modules that the state's going to require you to complete if you're part of this, the 51%, because that's something that's going to have to be done before you submit the application, and not after. Well, afterwards, there's going to be a second component, but you will have to complete at least the pre-application modules prior to. So keep an eye, and we don't know how long those are going to be, and likely going to be online, but keep an eye out on the state's website for when those are released.
Jeff, do you see anything that you want to point out on the timeline?
You know, I think one of the more important things is remember that applications get kicked out because they're incomplete and you lose. In almost every past process, we've had a number of folks that they didn't complete it correctly, or the state, they do research some of this information and have kicked out applications. So it's important, not only you're getting ready early, but you're getting qualified people around you and starting those checklists, because the cost of failure is fairly high.
Will, anything on the timeline before we go to closing thoughts?
Nothing really on the timeline. Details. And one last thing, and maybe you'll do this in the round robin, is be careful who your principal officer and board members are. Don't just pick people for that 51% because they meet the criteria. They will be your business partners. Be careful. Don't just jump in and say, well, you got a conviction, you're in. Being in a business is a marriage. You've got to make sure that it's the right choice. So vet your cohort of 51% especially, and make sure that you trust them. It's not just that they meet 3 of the 4 criteria, but you believe in them, you trust them.
All right. Well, this is going to be fascinating. I call it the summer of hope, not because of just the social equity aspect and the possibility, but because this is the summer that we will hopefully focus on what's positive about humanity and not what we fear. Anyways, but at META, June 23rd, and in July as well, social equity will be a hot topic. There's lots of industry professionals, from the C-suite, management, owners, partners, investors, all kinds of people wandering around. We invite social equity applicants to come participate and meet people, potential partners who understand the industry. And I know Clark and John are regular participants. Alex, I've seen you there as well. Guidant Law is always well represented, and we really appreciate you guys being there. Alex is Jeff as well. Sorry. So please join us at our live in-person meetings. META will also be hosting some events this summer, so stay tuned. We will email people about those, and they'll be very informative. And John, Alex, Clark, Jeff, Will, you guys will all be, you guys are great. It's just fantastic, your willingness to spend a couple hours sharing your knowledge and information with the community. I hope every social equity partnership and group is represented by Zuber, Lawler, Guidant Law, Rose Law Group, and Bianchi, and you guys divide them up 25, 25, 25, 25. So, because that's appropriate. You guys really have been putting in a lot of work for the community, and everybody needs representation. My God, do people need representation? So, closing thoughts. Who wants to go first?
Yeah, just thank you, Dimitri, for having me. It's been a pleasure. I always appreciate joining META. You guys put these events together very well. And to everybody listening, just piggybacking up on what Will was saying, it is a marriage. That's a great way to describe it. When you go into business with somebody, it is a marriage. And so trust is a very important component. But, having trust is good, but also having the correct documents in place to structure your business is also important, because if someone does break your trust, you can have something there to fall back on in writing. And that's what we attorneys are great for. And so I urge you to start seeking out attorneys, but also other professionals like CPAs that can help you start thinking about, what does this business look like from a financial standpoint? And so at Guidant, we're always happy to help you with that. Again, my name is Alex Karam, and it's been a pleasure. Thank you.
Johnny, you want to go next?
Sure, I'll go next. I guess my high-level thoughts on the rules, we've touched on this a lot throughout the discussion, is that this was a really hard job the department had. This was a topic in Prop 207 that had intense public scrutiny, as protests have demonstrated, and it's just one of these things where, no matter what you do, you're guaranteed to make some people unhappy, because either you're letting in the wrong people or you're keeping the right people out. I think it's interesting that the department probably adopted one of the more restrictive sets of criteria across the country. Usually it's, if you've been arrested or you're from one of these geographic areas, you can qualify. And that is pros and cons. But I'm sure there's a lot of people out here watching this that do qualify. And if you do, I would keep an eye out again for the educational materials that are going to be coming out sometime probably fairly soon. And of course, if you miss those, you're out of luck. So keep a close eye on that. Keep a close eye on further clarifications that are coming out to the rules about documentation and about geographic communities that'll qualify. And be sure too, if you're not 100% certain about that and you need to check that box, look out for opportunities to comment and, let the department know what kind of criteria you think they should be looking at when it comes to those communities. So that being said, thank you, Dimitri, for being here. Thank you, everyone, for watching. It was a real pleasure.
All right, before Clark and Jeff go, I have an opportunity. I haven't done this in a while. And Alex and John, you guys have escaped my grandfather's machete, where you guys get officially christened social equity mentors on behalf of MITA. So well done.
Oh, I feel different already.
Well, you should. But I know Jeff and Clark, they're carrying the magical powers already. So
That's right.
Jeff, you guys close it up.
I think, Dimitri, I want to plug a little bit. We are going to continue from a social equity training. We're going to have some deep dives coming up. There's additional information and forums that we will have to inform. So it'll be a great opportunity to bring questions, continue your learning. We expect everyone to participate in this industry, and sometimes you'll have a license and sometimes you'll do better servicing those in the industry that have licenses. So we're going to continue. Some are starting.
Yes, we're just getting started. Summer hope. Have I missed anyone? Clark.
How did you miss me, Dimitri?
Oh, man.
Well, thank you, Dimitri, for having me here at MITA. I think for those that have been watching, you've heard my viewpoints and thoughts about the program over these last few weeks, so I won't bore you with that any further. And also, if you have been watching for the last few weeks, you're probably more ahead than a lot of other potential applicants out there, and you're going to be learning a lot more from these MITA panels than you might in AZDHS's educational modules that are coming out, in my humble opinion. So, with that said, if anyone wants to chat further or needs help with the application, needs help with or has compliance questions, etc., I'm here. I'll leave my contact information in the chat box before we leave here today. And it's been a pleasure. And I look forward to meeting, some or all of you potentially in the upcoming MITA event. So thanks again, everybody.
All right, Dr. Humble, closing thoughts?
Thanks, Dimitri, for putting MITA together, building it from the ground up. It's been look at what you've done. Look at that meeting we had a couple of weeks ago. You got a lot to be proud of.
I appreciate that, Will. We're looking forward to doing a whole lot more and welcoming a whole group of new community members to the Arizona cannabis industry, community, et cetera. So, pay attention to the emails, folks. There's a lot coming out there. Weed Maps is sending down a whole crew for June 23rd. They're social equity specialists to see how they can help and to inform people as to what they do at the national level as well. So we'll see you June 23rd at the Foundry. Until then. Thanks, guys.
Adios.
Adios.